Yes.
Mehta, please maintain your cool.
Then they say, because we did not discharge our responsibility, therefore, if it is not registered, you have no right. You can't take advantage of your own wrong through a legislative fiat. Constitution bench judgment. How can the legislature go against that judgment and say there is going to be no Waqf by user because it's not registered?
You are saying that there is a direct judgment which says that registration is not necessary.
Yes, there's the Constitution bench. I showed your lordships. Rule of evidence cannot be done away by a piece of legislation. Says we require no evidence. We will make a diktat that if you are not registered, you will not be a Waqf para. Despite this, it was noted in the statements of objects and reasons of the Waqf of 2013, there is no time limit fixed in the Act for completion of such surveys. So far, only one state has completed the survey. This survey was still not been carried out by some state governments, such as Gujarat and Uttarakhand. Even now, this is in 2025. So there is no Waqf in Gujarat and there is no Waqf in Uttarakhand. Is that the argument? And because it is not registered, they'll all be taken away by the government? Yes.
Mehta, please maintain your cool. If you want, we'll increase or decrease the temperature.
Then he says, it is therefore clear that non-registration of Waqf properties that have continued unregistered is partly on account of the unscrupulous mutawallis and more prominently on account of the failure of the state governments to conduct a survey as mandated by the Act, despite a lapse of 17 years since this mandatory obligation was imposed on state governments. Your Lordship asked me the question, I told you, I have an answer to it. And this is the answer. This is a state responsibility by statute, which they accept they did not discharge. And then they say, because we did not discharge our responsibility, therefore, if it is not registered, you have no right. Unacceptable proposition of law. You can't take advantage of your own wrong through a legislative fiat. Then the argument that unregistered Waqfs by user can now be excluded. Unregistered Waqfs by user can now be excluded as over time of over 100 years to register Waqfs amounts to punishing the larger Muslim community, the beneficiaries of a Waqf, for its failure of the state government. Naturally, a number of Waqfs by user do not have appointed mutawallis, since the original instructions of the Waqf are no longer known. And hence, there would be no person who can be charged with the primary responsibility of registering the Waqf. It is also meaningless to argue that individual beneficiaries of a Waqf can also file an application for registration. Beneficiaries of the Waqf, such as namazis in a masjid or zaireen in a dargah, are merely visitors and will typically not be aware of the registration status of that place of worship. It cannot be settled. Suddenly, they won't be able to go. It is for this reason that both times that a proposal was introduced to deny legal protection to Waqfs for failure to register, and the same was omitted on the opposition of the Muslim community. My learned friend made a point of that. Who opposed? Of course they would oppose. They were being punished for the state's wrong, Malad. This is seen in the non-implementation of the proposed section 55E, Malad, which he pointed out. Sought to be introduced in the Waqf Amendment Act of 84. This can be seen in a statement of objects and reasons of 95, which mentions the provisions of 84 Act could not be enforced because strong opposition to its various provisions came from the Muslim community. The second attempt to introduce such a provision was Bay of 87, which was omitted in 2013 due to the opposition. Finally, the contention of the union is based on a fundamental misunderstanding of Waqf by user. A Waqf by user is not a Waqf created by use of non-Waqf property as a Waqf. Waqf by user is a rule of evidence by which a Waqf whose documents on proof of dedication have been lost by passage of time proves that it is a Waqf. Depriving a Waqf by user status on account of its non-registration or making its status contingent on such registration is directly in the teeth of the Constitution bench. And so just read 1134 because I don't want to read it, no time. Our jurisprudence recognizes the principle of Waqf by user, even absent an express deed of dedication or declaration. This is a Constitution bench judgment. How can the legislature go against that judgment and say there is going to be no Waqf by user because it's not registered? Whether or not properties are Waqf property by long use is a matter of evidence. The test is whether the property has been used for public religious worship by those professing Islamic faith. It's a burial ground or it's a mosque.
So you are saying that there is a direct judgment which says that registration is not necessary.
Yes, there's the constitution that I showed your lordships. W128 itself says so. 1134 says so. Doctrine of Waqf by user received judicial recognition. The decision of the Privy Council. Court of Wards of Property. This case concerned a public graveyard in Multan with a prominent Muslim saint was buried. Court of Wards acting with the property so-and-so proposed to sell certain property within the area. Muslim residents sought an injunction restraining proposed sale on the ground that entire graveyard was inalienable due to its long use as a public graveyard. And then 134 says evidence threshold is high. The most cases requiring evidence of public worship of the property is question of is since time immemorial. It was admitted that old mosque was, let's leave that out. So Malat, it is itself a rule of evidence. It can't be decided. A rule of evidence cannot be done away by a piece of legislation. Says we require no evidence. We will make a diktat that if you are not registered, you will not be a Waqf. Well, what basis do you say that?
Yes.
Then Malat, now this takes care of Waqf by user. Malat. Now, have you got that? Have you got that file, please? The WAMC? Just bring. Right. Kindly come to 158. You have seen this already. Then let's kindly come to page 63 of this rejoinder. It's a WAMC report itself. From 2013. Just see the middle, Malad.
Page 63.
Yes. Malad, this Rahman Khan was a member of the Rajya Sabha with me. And they worked for many, many years on this.
63
Middle of it says state UT Waqf boards where WAMC software have been successfully installed. Your Lordship has that?
Of rejoinder. Sir, I have your rejoinder 63 as some paragraph.
No, not rejoinder affidavit.
Rejoinder affidavit.
It's also there.
Rejoinder affidavit filed by Ejaz Makbul.
No.
Rejoinder affidavit on behalf of petitioner.
That's correct.
Yes, that's what we have in response.
Mr. Arshad Madani, not this, please. Allow me. It's all circulate. Anyway, mother. See, state UT Waqf boards where WAMC, DMS software have been successfully installed are Assam. See that? Then digitation work. It is only installed. The software has only been installed. Now what does it say? Pre-digitization work is in progress. We are on 2013. Pre-digitization work is in progress. In all the state UT Waqf boards where CCF setup is under development or completed, once the pre-digitization work is completed in all respects, then an actual digitization work starts. That is, all the ownership establishing documents are scanned next using WAMC and finally imported into WAMC DMS at the present respective premises for searching and retrievals. The state UT Waqf boards where digitization is complete is only 4 in this country. In